On April the 17th, 2008, the Office for Fair Trading, the OFT, announced that it had issued so-called Statements of Objections, SOs, against 112 firms in the construction sector in England. Many of them are well-known names. The OFT alleged that the named construction companies have engaged in bid-rigging activities in their dealings with public bodies, such as local councils, and in particular cover pricing. In other words, certain companies were together operating an illegal cartel. I'm going to explore this topic today with Stephen Gilchrist, a partner in the Regulatory and Business Crime Department of Saunders Solicitors LLP. Good afternoon, Stephen.
Good afternoon.
First of all, what is the OFT and what exactly does it do?
Well, the OFT is a non-ministerial government department established by statute in 1973, and it's supposed to be the UK's consumer and competition authority. Its mission is to make markets work well for consumers, encouraging businesses to comply with competition and consumer law, acting to stop hardcore or flagrant offenders, studying markets and recommending action where such is required, and empowering consumers with the knowledge and skills to make informed choices.
What is a cartel exactly, and why is it illegal?
Well, in its simplest terms, a cartel is an agreement between businesses not to compete with each other, usually by agreeing on prices or output levels, discounts, credit terms, which customers they'll supply, which areas they'll supply, and who should win a contract, and that's known as bid rigging. Each of these is prohibited by the Competition Act 1998 and Article 81 of the EC Treaty. In addition, the Enterprise Act 2002 makes it a criminal offence for individuals to dishonestly take part in certain specified cartels, essentially those that involve price fixing or market sharing, limitation of production or supply, or indeed bid rigging.
Yes, bid rigging. That's what all the recent fuss was about. Tell us about some of the allegations.
Well, it's an interesting case. In this case, the so-called bid rigging also involved what's known as cover pricing. This describes a situation where one or more bidders collude with a competitor during a tender process to obtain a price or prices which are intended to be too high to win the contract. The tendering authority, for example a local authority, local council, or indeed another customer, is not made aware of the contact between the bidders. So it's left with a false impression about the level of competition. This may result, of course, in it paying inflated prices.
And this sort of activity is illegal?
Well, it certainly is. Cover pricing arrangements have previously been found by the OFT and the Competition Appeal Tribunal to be illegal and in breach of the Competition Act 1998 due to the restrictions on competition that arise. In this case, however, the Statement of Objection formally alleges that a minority of the construction companies concerned have variously entered into one or more arrangements whereby it was agreed between them that that the successful tenderer would pay an agreed sum of money to the unsuccessful tenderer, and that's known as a compensation payment. These are more serious forms of bid rigging and are usually facilitated by false invoices.
How does a cartel investigation normally start?
Well, very often from a whistleblower. In fact, in this particular case, the OFT's investigation originated from a specific complaint in the East Midlands in 2004, but it quickly became clear to the OFT from the evidence that the practice of cover pricing was in fact widespread.
What can the OFT do when they suspect a cartel is operating?
Well, the OFT has strong powers to investigate businesses suspected of breaching the Act and to impose tough penalties on those that do. For example, it can obtain documents and information from businesses suspected of committing an infringement, as well as from their competitors, customers or suppliers. It can enter and, where it's obtained a warrant, search premises. The OFT will either send a written notice to a business requiring documents and or information to be provided, or visit premises to obtain the information that it needs.
What happens if someone doesn't cooperate?
When anyone who fails to cooperate with the investigation, for example, they don't respond to a notice or they refuse to provide requested information or documents, obstructs OFT officials or hides or destroys or falsifies relevant documents, may be guilty of a criminal offence. That's punishable by a fine and or in some cases imprisonment.
So when the investigation is complete, the OFT can issue this Statement of Objections. What is the Statement of Objections?
It's a bit like an indictment, I suppose, in a criminal case. It gives notice of a proposed infringement decision under the Competition Act 1998 to the parties involved. The parties then have the opportunity to make written and oral representations in response to the case set out by the OFT. Those representations will be considered by the OFT before any final decision is made.
And what can the companies concerned do about it?
Well, firstly, if you alert the OFT to a cartel that you are or have been involved in, you may be dealt with leniently. Businesses may be given a total or partial immunity from fines, and individuals may be given immunity from prosecution. But to qualify for leniency, you have to admit participation in the cartel, you have to cooperate with the investigation, and you have to stop your cartel activity straight away.
What if you don't want to confess?
Well, after the SO has been issued, the company has 30 days to make representations against the allegation. The OFT will then have to make a decision on the information it has before it.
And if the OFT decides that there has been unlawful conduct?
Well, then it has the power to impose a financial penalty on the company. Now, the nature of the penalty will be calculated following a 5-step approach. There's a calculation as to what's known as the starting point, having regard to the seriousness of the infringement and the relevant turnover of the company, the undertaking.
Is there a maximum penalty?
There is a maximum penalty, and it's 10% of the undertaking that is the subject of the investigation.
Can there be an appeal against a decision by the OFT?
Yes, there can be an appeal to the Competition Appeal Tribunal. It's designed to hear appeals on the merits in respect of decisions made under the Competition Act 1998 by the OFT. Cases are heard by a panel consisting of 3 members, either the President or a member of the panel, or Chairman, and 2 ordinary members. The members generally will be lawyers, judges of the Chancery Division, and lay members who have an expertise in law and or related fields.
Finally, Stephen, you mentioned earlier on the Enterprise Act and the criminal cartel offence. What's that about?
Well, this was a new offence introduced by the Enterprise Act 2002. It's a criminal offence for individuals who dishonestly engage in cartel agreements. And an individual is guilty of that offence if he or she dishonestly agrees with one or more other persons that undertakings will engage in one or more of the prohibited cartel activities. These are price fixing, limitation of supply or production, market sharing, and bid rigging. And if you're found guilty of this sort of offence, then there will be a substantial fine, but you can go to prison for up to 5 years if the case is tried in the Crown Court.
And so if you think you or your company may be in trouble, what do you do?
Well, that's easy. You need to take urgent legal advice in order to assess your position, determine the most appropriate course of action to take, but you need definitely to take expert legal advice.
Stephen Gilchrist, thank you very much.
Thank you.